In the George Zimmerman trial today, the prosecution focused on DNA evidence this afternoon, but the focus this morning was on Zimmerman's background and specifically a college criminal justice course he took. Prosecutors hoped to show that Zimmerman was more familiar with Florida's self-defense laws than he intimated in an interview with Fox News last year. It seems to be part of a prosecution strategy to broaden the lens of the case beyond just the night of Trayvon Martin's death. Will it work? MSNBC's Craig Melvin is in Sanford, Florida today. Thank you, Craig, as always. Why don't we just let you give your sense of what you're reporting on what happened today in this perhaps last day of prosecution testimony?
Yeah, you know what, Chris? We thought at least for a while it was going to be the last day. Judge Nelson indicated earlier that the state had told her that they wanted to rest its case today. That did not happen. Judge Nelson adjourned to the jury home for the 4th of July holiday, but told them to be back earlier than usual on Friday. They're going to come back Friday morning at 8:30. It's expected being the operative word here, that the state at some point Friday morning or perhaps Friday afternoon will call one or perhaps both of Trayvon Martin's parents, but we do expect to hear from Sabrina Fulton on Friday. It's widely believed that she is going to be the last witness for the state. At that point, the prosecution will start to present its case. As you indicated, much of the day spent on DNA evidence. Anthony Gorgone, DNA expert called by the state, major highlights from his testimony. For the most part, there was none of Trayvon Martin's DNA found on the gun grip, none of George Zimmerman's DNA found under Trayvon Martin's fingernails. On cross-examination, the defense did spend some time raising some questions about the number of varied ways that DNA samples could be degraded. Also, again, as you indicated, the day started with a win for the state. The state had been arguing to get this evidence, in that George Zimmerman did know a little bit more than he let on about the law. Also, that he wanted to be a cop. We heard from someone from the Prince William County Sheriff's Department in Virginia who said that, Zimmerman applied several years ago to be a cop. That application was rejected because Zimmerman had basically a poor credit history. We also heard from Captain Alexis Carter, who taught a criminal litigation course to George Zimmerman, said that Zimmerman was an A student in that course, also said that in the course they covered stand your ground. You'll remember, of course, the Fox interview that was played for the jury yesterday. Zimmerman said point blank he had no knowledge of this so-called stand your ground law. But today, again, his professor saying that was essentially not the case. Also allowed into evidence an application to ride along with the Sanford County Police. Again, the state trying to demonstrate that George Zimmerman wanted to be a cop, was perhaps a vigilante as well. So again, that was the evidence that was introduced this morning. There was also some firearms evidence. Amy Seward, firearm analyst, testifying earlier today that based on what she discovered, she could tell that the 9mm was fired essentially at point blank range as well, that it was touching Trayvon Martin's sweatshirt when it was fired, Chris.
Well, let me get back. Thank you so much for that, Craig Melvin. As well, let me get to Lisa Bloom and Joseph Haynes Davis for joining us as well. I want to start with Lisa Bloom here. Let me talk to you about or ask you about this whole thing about the sweatshirt with the hood on it, and whether the gun was in contact with the sweatshirt, which apparently they stipulated it was. The gun was up against the sweatshirt, but it wasn't necessarily proven so far to be up against the body of Trayvon Martin, who died. And my question is, if it's on the sweatshirt, would they be thinking he's carrying this sweatshirt with him? How would it be hitting the sweatshirt and not the body in any reasonable scenario? I just don't understand this discussion.
Great question. So here's what the defense says. The defense says that Trayvon Martin was straddled over the body of George Zimmerman, and his body was diagonal over him. And because of gravity, the sweatshirt separated from the body of Trayvon Martin. And that's why the shot went through the sweatshirt. Right. It was touching directly, but not the body. And they show that the physics of that essentially establishes George Zimmerman's story, that Zimmerman was on the bottom, Trayvon Martin was on top. That's what the defense argues.
But this was a prosecution witness, and it just seems so many times in the last several days that would look to be a prosecution spectacle, and an effective one turned out to be coming the other way. You weren't even sure who the witness was. Whose witness it was?
Well, that has happened a number of times, and it's going to take the medical examiner to come in and testify about the autopsy on Trayvon Martin's body, and we'll hear more about the flesh wound that bullet caused.
Okay, let me go to Joseph Haynes Davis. Joe, thank you for joining us here. It seems to me the prosecution case is wide. It's a very wide lens. They're not trying to fight, at least to focus on the moments between these two men encountered each other that terrible night. And between those moments, of course, there are even seconds it relapsed between the meeting of these two in a horrible way and the death of one of them, Trayvon Martin. But they want to pull back the lens to look at a mindset question, a question of veracity. Let's get into this guy who's the defendant here. Let's talk about his wanting to be a policeman, his possible vigilantism that night, his possible profiling. That word has gotten into evidence. Tell me why they pull back to the wider lens.
Well, they have to a very large degree, Chris, and thank you for having me, because the fact of the matter is the prosecution has had some tough days with their own witnesses. I've been suggesting in theory, that the prosecution in their summation, in their closing, might want to ask the jury, given the fact that George Zimmerman was a concealed weapons holder legally and had the gun legally, as to whether or not he acted as a reasonably prudent concealed weapons holder with a Florida concealed weapons license on the night of February 26, 2012. And that includes not leaving out of his safe zone, which was in his car. I mean, there are a tremendous number of concealed weapons holders in this state, Chris, I being one of them, that knows that when you are out and about and you see something, quote unquote, suspicious, you make the call to the non-emergency number, you give the information, you step away, you walk away, you might walk back to your home so that you are not looking like you are pursuing or aggravating the circumstances. You are not deputized to begin to start the search. If, when you are retreating, for lack of better terms, back to your house or whatever, if you're out of the car, walking the dog or something, and that threat comes toward you, then it's another issue. But in this instance, if Mr. Zimmerman does not get out of the car, we are not having your show tonight.
Okay, let's hold on to that. Hold that thought, the audience, too. We'll be right back with Lisa Bloom and Joseph Haynes Davis. You're watching Hardball, the place for politics.